Okay, everyone, good evening. Though it doesn't feel like evening, it's sunny, it's warm, it's hardly Boston. I'm Catherine Allgor. I'm the president of the Massachusetts Historical Society, and I'm truly delighted to welcome you this evening for what I think is a truly special program. Now, as you may know, that Massachusetts has had a number of firsts. First public park in America, the Boston Common, the first American subway system, the first American public library, the first use of ether as an anesthetic, and of course, the first historical society. Yeah. Thank you to our regulars who know that I love a cheap applause line. Yes. And of course, the Commonwealth was also the first court to recognize the right of same-sex couples to be married. Now that's an applause line. The landmark decision in Goodridge versus Department of Public Health went into effect 20 years ago on May 17th, 2004. I'm honored to be joined this evening by the Honorable Margaret Marshall, former Chief Justice of the Massachusetts Supreme Judicial Court, Dr. Nancy Cott, Harvard University, and Mary Buonato, GLBTQ legal advocates and defenders, or GLAD, to discuss the Goodridge case, the history of amicus briefs, and reactions to the decision, and more. Margaret Marshall served as the 24th Chief Justice of the Massachusetts Supreme Judicial Court, the first woman to hold that position. She wrote more than 200 opinions, including the groundbreaking decision in Goodridge versus Department of Public Health, which is the basis of our program. Nancy Cott is an American historian, professor, and author, specializing in women, gender, marriage, and citizenship. She has testified on same-sex marriage and is the lead author of numerous, I'm going to say this, amicus curiae? Curiae, thank you. Thank God there are lawyers in the audience and here too, in numerous state and federal courts. Mary Buonato is an attorney at GLAD. She was the lead counsel in the Goodridge case, and in 2015 successfully argued before the U.S. Supreme Court in the historic Obergefell versus Hodges case, which established the freedom to marry for same-sex couples nationwide. So, history-making women here, we're about to make a little bit more. So I'm going to start and give you the floor, Mary.
Thank you so much. And I am actually really thrilled to be here. I did double major, including history, and I've always been historically minded, and I bring it to all the cases, and this was an area where that's been very rich, and I'm not going to talk about that so much because Professor Cott will do so well. So I want to just say a few things from the outset. Number one, Obergefell never would have happened without Goodridge. And Goodridge really was the template for everything going forward. And there was a great deal going forward between 2003 and 2015 when the Supreme Court ruled. Our focus today is definitely on Goodridge. And I wanted to just say a few things about it. Sometimes people act as though I decided over the weekend to file a marriage case and then filed it on Monday. And I often get those questions, and I'm like, how do you get 14 plaintiffs like that? But anyway, I wanted to just say it was a very considered decision, because what is clear when you do the kind of work I do at an impact legal organization, where you're trying to make sure that the protections and freedoms that apply to other people apply to LGBTQ people too, you have to think really carefully about your timing. You know, is the court, is the legislature, is the public, going to be able to embrace this, even if not immediately? You have to think about your arguments, and are they right? And pressure test them constantly, and what are the concerns on the other side? But I will say this, in the end, the reason we filed this case in Massachusetts in April 2001 is because I had been approached, I'd been at GLAD for 11 years by that point, I had been approached constantly by people who said, why can't we marry? And in our intake line, or hotline, whatever you want to call it, there were periods where between half and 2/3 of the calls coming in would have been resolved if people had married, if they had legally recognized familial relationships with each other and with their children. And it was just impossible to look away from that. So I wanted to say that that's really what it's about in the end, is the people. and there were people who were harmed and wanted to do something about it. So I also have to say that I don't mind if people call me idealistic, because I do, in fact, I'm going to stake my claim on believing in our Constitution and its principles, and that they matter going forward. I'm not going to give up on that, and I didn't then, even though, honestly, so many people, even in the LGBTQ community, thought I was really out there, to put it mildly. But I really do believe that, you know, what the courts had said over the years, that marriage is a basic right, it's a civil right, it's a vital personal right. Yeah, exactly. And so then why exactly would you take this one small group of people who are also of age, not currently married, who are willing to make that commitment in marriage, and say, just you can't participate? And that's the equality and civil right part of it as well. So we were on, you know, by the time we got to 2001, we felt like we had done so much work trying to understand the Massachusetts Constitution, which is incredible. I don't know if you've done a program on that. It is an incredible Constitution. Maybe Chief Justice Marshall will talk about that. You know, just written by John Adams, ratified in 1780, so much about anti-favoritism, equality of all individuals, and so on, which all shows up, which I'll get to in a second, in the opinion. So those were some of the reasons that we filed, but it was a very considered choice, and the reason we pursued this under the state constitution was because that would confine this to Massachusetts. You know, Massachusetts is allowed to construe its own constitution and to say our marriage laws, you know, whatever they are, actually just deny some of the protections and confines and boundaries that our Constitution sets out about liberty and about equality. And we knew that that would be a way of, you know, should we win, and believe me, we weren't overly confident about it, but we wouldn't have filed it unless we really thought we were right and we really thought we had a chance at winning. So in any event, you know, we had done everything we could before we filed. We recruited, you know, we talked to actually hundreds of people who wanted to participate in this, because we'd had a long list over the years of people who'd asked us about it, but we wanted to make sure we had, you know, just people in different parts of the state of different ages and different demographics of every sort, and to try to, you know, to talk about why they wanted to marry and actually just be incredibly personal about it and vulnerable and tell the truth. And that was their job, to do that again and again. And they were so brave. And as things heated up, I have to say the courage and the integrity came through even more in terms of them really talking about doing something that clearly would have benefited them, but they were really doing it as well for their own children and for future generations. And I can't personally help but admire that. So we were off and running in April, as I just said. And I want to just introduce one other thing, because people often think, how does change like this happen? And I'm often asked, like, boy, don't you really think this happened fast? And I think, well, it depends on when you start counting. And there's a lot to say about that, going back many decades. But in addition, like, if you think about Massachusetts, and I assume a bunch of you are residents here, marriage wasn't necessarily the thing that, you know, Representative Frank or Representative Studs were talking about, but we had 2 gay representatives. We had a 19-year fight about trying to pass a non-discrimination law based on sexual orientation. You know, we had a later law about students not being discriminated against based on their sexual orientation. And we had a lot of failures. You know, it was impossible to get a family policy of health insurance for a couple, no matter how long they'd been together. And even with municipal and state employees, you know, you couldn't get it. And at one point, some of the mayors, like Mayor Menino in Boston, finally just said, I'm issuing an executive order, you can get health insurance for your partner if you're a city employee. And that had to go to the state Supreme Judicial Court. And they said, no, you don't have the power to do that. So there was just so much, I think, over time, more familiarity with people. You run into them in the grocery store. One of our clients was a Little League coach. Like, you just get to know people over time. There are lots of access points. And I think over time, people began to see and become familiar with LGBTQ people, and that made such a difference when we finally got to marriage. And just to jump ahead for a second, like, there was a poll from the Herald shortly after the decision came down in November 2003, and the headline was, "Gays A-OK in Bay State." And that was because the populace was split evenly. And that's kind of incredible, thinking that it was 2003. All right, so I need to say a few things about the law. I've already said the Massachusetts Constitution is extremely protective of individual dignity and equality. In addition to that, I will say that there have been some other developments in the world. You know, Hawaii's Supreme Court in 1993 had said, well, maybe this case on behalf of 3 same-sex couples shouldn't have been tossed out. That led to a lot of conversation about marriage. And then prior to Goodridge, I was counsel with 2 lawyers in Vermont in a case there, which in 1999 ended with a ruling saying, you're right, under the state constitution, same-sex couples should have all of the same protections and benefits under law as different-sex couples. But we will leave it to the legislature to figure out how to do that, which resulted in the nation's first ever civil unions law, which was intended to be parallel to marriage at the state level, but not marriage. And I will just say marriage itself, saying you are married, being married is itself a protection because everyone instantly understands you are a family and that these people have defined themselves by their love and commitment to one another. In any event, it was still a way for people to wrap their heads around the idea that, okay, the gays have a status now, they're gonna have rights. And that was, I think, in its own way, what some people call quality practice, like getting used to the idea. In any event, one of the first questions to me in oral argument was, well, do you want what Vermont has? And I said, no. We do not want what Vermont has. It's marriage that is equal, and it is marriage that's going to provide the greatest protection. And that's what we think is merited under the state constitution. So there have been those developments. As I said, we found a bunch of plaintiffs. But I want to talk about one other thing, which is, you know, I'm at this point like in a very small nonprofit, you know, trying to do good work to help people, change the law incrementally and so on. And at the same time, I knew that we had so many great arguments that I was not going to be able to make fully in our briefing. So I started testing the waters, and actually Nancy Cott here is one of the first people I reached out to say, you have so much to say about this topic. You know, would you be willing to share your expertise with the court? And I made a few other calls, you know, not knowing where people were necessarily, like people who were, like, wrote the treatise on family law in Massachusetts and said, there's this argument, you know, about procreation is the one and only defining feature of marriage. What do you think about that? And they said, much more complex than that. You know, that's not right. And they wrote a brief, and I just want to say that we were able to assemble, and again, totally people who were just willing to do this and share their expertise to put incredibly excellent information before the court. And that, too, I think set a real standard going forward in cases. But I want to say a few things about the opinion. Probably should have talked the whole time about the opinion, because the opinion is beautiful. And I mean, it's incredibly well written and is quite a story. And in that, you learn not only about the couples and why they came to this and who they are, you learn about the Massachusetts Constitution and its richness. You learn about marriage, because people think they know about marriage, but you learn that it always has been a civil institution, even as, of course, we all respect that faiths have their own sacraments of marriage or religious rites of marriage. But government's been involved in marriage from day one, and this is something that I think Professor Cott can talk about, or Dr. Cott, whatever. Okay. And just so much more. And I want to just say that I need to read some things to you just for a quick second, if you'll bear with me. But like one of the things that really jumped out at me after reading this whole opinion, I mean, many things did, but there was this piece where, you know, the court had talked about the enormous numbers of changes, very deep changes in marriage over time. And so the court, when it's very close to the conclusion of the opinion, says, it's, you know, these are concluding thoughts, obviously. The marriage ban works a deep and scarring hardship on a very real segment of the community for no rational reason. The absence of any reasonable relationship between, on the one hand, an absolute disqualification of same-sex couples who wish to enter into civil marriage, and on the other, protection of public health and safety or general welfare, suggests that the marriage restriction is rooted in persistent prejudices against persons who are or believed to be homosexual. The Constitution cannot control such prejudices, but neither can it tolerate them. And then goes on to say, you know, what you would expect. So I just want to put out there that the civil rights dimension of this case is argued throughout. It's not argued, it's presented throughout. It's very hard to read the opinion and not come to that conclusion. And to have said that at this time in 2003, was incredible. And I want to tell you a couple other incredible things. Okay, so I get the opinion. One second, okay. So I go up to the courthouse to pick up the opinion. Suffice it to say, I didn't turn to the right page, so I thought we'd lost. But when I finally get to the right page, what I see is, first sentence, marriage is a vital social institution. The exclusive commitment of two individuals to each other nurtures love and mutual support. It brings stability to our society. For those who choose to marry and for their children, marriage provides an abundance of legal, financial, and social benefits. In return, it imposes weighty legal and financial and social obligations. The question is this lawful? Here's the answer. The Massachusetts Constitution affirms the dignity and equality of all individuals. It forbids the creation of second-class citizens. And that's what you see from beginning to end of this opinion. You see focus on the Constitution, regardless of what was expected back in 1780, because in 1780, the Constitution itself recognized that these were supposed to be enduring principles over time and weather radical changes over time. So here we were, and I just want to say, this is incredible. The second quote is the one that's always read at weddings, so I just have to say this very briefly. If I could find this. Okay, I'll do it later. But you've got to hear this. I know I talked too long. You've got to hear this. I'll come back to it.
Thank you so much.
Okay, I'll stop there. Okay.
Nancy, would you like to, I think you've been cued already, so yes.
I've been queued up, yes. I'm going to talk mainly about my own experience writing the historian's amicus brief in the case. And how did I get into it? Because Mary Buonato recruited me, and she somehow knew in 1999 that I was about to publish a book on marriage as a public institution and state involvement in marriage. And so I first learned what Mary was up to when she asked me to go speak to the Vermont Joint Legislative Committee that was trying to decide whether Vermont should have civil union or marriage. And there, it was fascinating. It ended up being a 3-hour seminar on a holiday. And there I discovered, to my shock, that even a legislator in Vermont did not know that marriage was a civil institution. She assumed it was a religious institution because, of course, one sees it performed in a religious setting. And so that became the first task of the historian's amicus brief, to explain that marriage in the United States, in all of the United States after the Revolution, had always been validated by civil authorities, and that therefore it was those civil authorities, legislatures and courts, that had the ability to change what marriage meant, who was eligible, what its responsibilities were, and so on. So after Vermont, where we fought valiantly, but they did choose civil union, Mary asked if I would be interested in writing a historian's brief in the Goodridge case, and I got a colleague, Michael Grossberg, to collaborate with me. He was the author of a very well-known 19th century book, text on 19th century domestic relations law. And so what was the historian's brief going to accomplish? Well, in addition to making the point about civil marriage, we wanted to show, led by Mary's suggestions, that marriage could change and had changed over 3 centuries by the actions of legislatures and courts, because the other side was maintaining, how can you possibly alter marriage in this way? It's always been the same thing from time immemorial. And so we could show that, in fact, over time there had been major changes in marriage, and that those changes had moved consistently, though slowly, toward making marriage a more equitable partnership with more equal roles on both sides, and that it was reasonable, thus, that a marriage between a couple of the same sex would be the next phase in that progression. So the 3 changes that we emphasized were these. These were areas we considered very significant, and lest they be put down as trivial, we made sure to show that at the time they were transpiring, critics then said, you can't do that to marriage. It's going to absolutely change the essentials of the institution. It would be eviscerated. So the first one was about the relation between husband and wife. And we documented the slow but steady erasure of laws that had made the husband the superior to his wife with dominion over her, and in fact had evaporated the wife's economic and political personae and made her part of her husband, made Lucy Jones into Mrs. John Smith. And through many decades, these laws were dismantled so that in the last very significant phase, which was the 1970s women's rights revolution, marriage in the law, the rights and responsibilities of marriage had been made the same for both spouses, whereas historically the husband had quite different responsibilities as well as rights from those that his wife held. Then the next change was about, not about gender, but about race. And we discussed the way in which those laws in many, many parts of the US, and I should parenthetically say this was not a Southern phenomenon only, there were 40 states and or territories in the United States that at some time in their history, including Massachusetts, although it was brief here, at some time in their histories had laws banning or criminalizing, or both usually, the marriage of whites to persons of color. And some states had gradually let go of these laws, and then definitively in 1967 in the Supreme Court opinion, Loving versus Virginia, they were overthrown and marked by the court as evidence of an attempt to impose white supremacy. So this was another validation that the marriage institution was being changed by legislatures and courts to emphasize that it is based on choice and consent and was a fundamental right. The third change we stressed was the invention of no-fault divorce, which was much more recent, because there had been divorce in most, I'll say, American states for quite a long time, but it was something that the state was a very important party to and set the grounds of, and you had to prove that you met those grounds before the state, et cetera. No-fault divorce wore away at this notion that, first of all, that marriage had to be lifelong and that the state had a principal role in it, so it re-emphasized that the qualities of a marriage were really up to the partners, and it was their decision-making, not the state, that should characterize it. Now, did this brief influence the court? Well, the Chief Justice can answer that better than I can. Her opinion does mention these same three areas of change, so perhaps she did. I should mention, by the way, that in writing this brief, and it was my first of what became many, I had no idea that the judge or justices were not bound to read the thing. It's actually optional. But I naively thought, oh, I'm writing this for the person deciding the case, so I guess that's a good way to approach it. I want to just mention on the impacts of Goodridge that, of course, was a fabulous success in a campaign that actually, I see it as starting in 1962 with that first case, but it was a small campaign until the 90s when it became very major, and it certainly had the impact of making a lot of couples very happy in Massachusetts. They thronged the License Bureau on May 17th, 2004, which was the first day that this was allowed, and it was, that date, coincidentally, was the 50th anniversary of the announcement of the Brown v. Board of Education opinion from the Supreme Court. So Goodridge mattered in just the way it was intended, but also I think in further ways. It further inspired activists to think they were going to get ahead, and as Mary mentioned, it affected every other case going forward. It importantly enabled lesbians and gay men to feel that the state had validated their love and thus their lives and themselves as full citizens. I felt from the beginning that that marriage is a civil right. The book that I had been writing was very emphatic on that point. So this really mattered to people in more than one way. And I wanted to just mention parenthetically something that came up because I heard it in an interview just a few weeks or a month ago. Governor Healy was being interviewed about her career and mentioned something along these lines, which I think really is worth repeating. So the interviewer asked her about where she had served, and she mentioned that she had been employed in the Attorney General's office for 7 or 8 years when she decided to run for the position of Attorney General. And the interviewer asked her whether she'd felt kind of exposed or troubled about being the first lesbian to run for this office. And she said, not really. She knew she was experienced, highly experienced for the job. And since this was Massachusetts, and Massachusetts had for 10 years already allowed same-sex couples to marry, she figured she would be valued for her talents, and just like any straight person would be. So I was really struck that she saw that the marriage change as signaling in that way to her. I was thinking of mentioning also another thing that involves Healy and really Martha Coakley, who was Attorney General at the time, which was a case that the state of Massachusetts brought against the Defense of Marriage Act, the federal law passed in 1996 that defined marriage for federal purposes as only between a man and a woman. I wrote a different sort of historian's amicus brief for that, but I know we're short on time, and if it comes up, I can mention it later. Instead, I wanted to mention a case that happened slightly before the Goodridge case, and I think laid crucial background, and also had a very important historian's brief. That is Lawrence versus Texas. This was a case in 2003, decided very soon before the Goodridge case was heard. And in it, the Supreme Court struck down Texas's law that criminalized sodomy between persons of the same sex. And in striking down Texas's law, the court was overruling a precedent of only 17 years earlier called Bowers versus Hardwick, which had upheld a similar law in Georgia. In that earlier decision, the court's upholding of the Georgia law had claimed that, quote, homosexual sodomy, end quote, had been a crime for many centuries, and so it was perfectly justifiable for the state of Georgia to continue to have a criminal law of this sort. Historians, led by George Chauncey, submitted an amicus brief in Lawrence to show how flawed the history in Bowers v. Hardwick had been. The historians, I signed the brief, there were about 8 of us who signed. The historians pointed out that sodomy in past centuries meant any non-procreative conduct. It could take place between people of the same sex. It could take place between men and women. It could take place between humans and animals. All of those things were sodomy in the ancient laws against it. Sodomy was not historically and anciently particularly about homosexuals. In fact, you could say there weren't even homosexuals in those years, but I won't get into that. So Texas's law, we historians argued, rather than being the relic of something ancient, was actually a quite recent law, and it was a law that was marked to control, quote, homosexual conduct, end quote. It was part, in fact, of a wave of legislation that a number of states had passed in the post-World War II era because of various social panics that were going on about sexual deviance at the time. So we argued that Texas's law was meant to create a class of second-class citizens among homosexuals by targeting them and stigmatizing them, and thus denying them due process of the laws and equal protection of the laws. The Lawrence opinion, which was written by Justice Anthony Kennedy, invalidated not only the Texas law, but all the anti-sodomy laws in the nation. And I bring this up tonight because I assume that had Lawrence v. Texas gone the other way and upheld Bowers v. Hardwick, thus allowing states to criminalize same-sex intimate conduct, that the outcome of Goodridge would not have been possible. And I would be glad to hear your comment on that later. So in closing, I just want to make a remark that brings us somewhat up to the present day, because Justice Kennedy's understanding of history in that Lawrence decision, in particular his understanding of the history and traditions of the United States, diverged very sharply from what the majority of today's Supreme Court holds. You may know that this history and traditions approach is, that is in constitutional interpretation, and particularly of the Due Process Clause, this approach is favored by a majority of our Supreme Court, and it was crucial in underlying the Dobbs decision that overruled Roe v. Wade 2 years ago. In the Dobbs decision, Justice Alito said that a right to abortion never existed at the time the 14th Amendment was written in 1868, and thus no such right could be inferred from it today. In Lawrence, Justice Kennedy reasoned very, very differently. I quote him. He wrote, "History and tradition are the starting point, but not in all cases the ending point of the substantive due process inquiry," end quote. And he went on a bit, speaking about the men who had written the 14th Amendment, saying, I quote again, "They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress," end quote. So in closing, do historians' briefs matter? That is, were the historians' briefs in Goodridge and in Lawrence, both decisions which came out the way the historians said they should, were those briefs superior to, more persuasive than the historian's brief in Dobbs? I doubt it. At first, in years of writing amicus briefs, I really thought that historians were very influential. That is, in these marriage cases, arguing for equal rights to marriage for same-sex couples. Unfortunately, I am no longer so naive. I think that historians' briefs operate only indirectly, in affecting outcomes, that is. Judges will use historians' offering if this accords with the direction in which the judge is leaning anyway. If not, not. Nonetheless, I do think that historians should continue to do this work for the sake of the record and their field, at the very least. Thank you.
Justice Marshall.
Well, those are two very difficult presentations to follow, but let me start at the beginning. I've listened to Attorney Buonato talk about the many years that she worked on the case, and I'll tell you what it feels like from the other side. In the Supreme Judicial Court, we have a tradition that the justices do not share their views before they hear oral argument, so that the only thing that I knew when I walked onto the bench, and I forget the date, but maybe March 3rd, the lawyer would remember. I knew I had read all of the record of the case, the complaint from the beginning and all the way through. I did make it a practice to read amicus briefs if I possibly could before oral argument. It wasn't always possible to do that because sometimes there are no amicus briefs and sometimes they are not. Maybe I should tell people that an amicus brief, amicus friend, is a friend of the court. In theory, these are briefs written by people who are not litigants. They are not parties to the case, but they feel they have something to say that might help the justices make a decision. It is not a practice that lacks controversy, because sometimes things come into an argument that in fact haven't been tested by the parties beforehand. And so it can be quite a dangerous practice, and I'm thinking here not so much about Goodridge, but about cases that involve scientific work, for example. Generally speaking, you want to have both parties an opportunity to question each other and their experts, and then when somebody files an amicus brief, particularly at a higher court like a Supreme Court, a Supreme Judicial Court, those theories haven't been tested. In this case, I think there were two things that were happening in Goodridge, in Massachusetts. The first was this was a case which made very clear to the justices that neither the plaintiffs nor the Commonwealth wanted anything other than marriage. It was an up or down. In other words, you've heard Mary Buonato saying she did not want civil marriage. The Commonwealth didn't want civil marriage. The Commonwealth wanted neither. It was not an option. The way I know that is I used to teach my law clerks, look to see what the parties are asking for. You turn to the last page of the brief, what are they asking for? And the Commonwealth is asking us to dismiss the case. And so there have been developments around in the marriage area, but I have to say, if you're sitting on the Supreme Judicial Court and you're deciding a whole range of other cases, I did not have at my fingertips what had been happening in the situation of same-sex marriage for the past 3 or 4 years, let alone the preceding 50 years. It's now 60 or 70 years that the first claims were made for same-sex marriage. And so I, in some senses, was looking at the question of marriage for same-sex couples completely new. We had not had the question before us. And I don't make a point of reading the decisions of other 50 states. So that was not on my horizon. I knew a fair amount about discrimination in terms of employment and housing and benefits, because those have been cases that the court had addressed, but not marriage. But the second thing that had been going on in Massachusetts is in the courts, there had been a number of decisions that had been made because families, the look of families had changed. So one can look at marriage, as Professor Cott has done, and to say there were very big changes, huge changes about marriage itself. Coverture, the sort of absorption of a woman into a man's world was one, interracial marriage with another. But there were all kinds of other things happening, partly because of no-fault divorce, but simply because in the sort of classic, if I want to think of a case, where you had a father and a mother and a child, if there was a breakup of the marriage, generally speaking, overwhelmingly speaking, custody went to the woman and the man had to support. That was the classic model. And by the post-World War, Second World War, that was clearly not working. And there were people living together in familial relationships where there were grandparents, there were more than one parents, there were many divorces, there were relationships being established with children, which had nothing to do with their biological creation at all. And so the courts had increasingly been asked to address the question, Now, one could say that it is a better way to do that might be to go through the legislature, and it often is, but sometimes the legislature either won't act or simply hasn't acted. And people come to court because when they have a problem on their minds. So, for example, one of the early cases in Massachusetts was same-sex couples came and said, we would like to adopt our child. Can we adopt our child? We can't get married. There's no marriage, but can we adopt this child that we share as parents? It was a very interesting, new, complex case. In many states, even where there had been a heterosexual marriage and a subsequent divorce, if one of the parents was gay or lesbian, there was an irrebuttable presumption that they could not be a good parent. An irrebuttable presumption means it doesn't matter what evidence you introduce, you will not get custody of your child. The very fact that you have moved out of a heterosexual marriage into a same-sex relationship means you cannot get access to your child. So there were complex problems that families were facing, and Massachusetts was one of the first states that said, if you are a same-sex couple and you would like to adopt a child, you can adopt a child. Now, why would that make a difference? It makes a huge difference in terms of all kinds of rights and privileges and also responsibilities. It makes it easier for the society to deal with adults and children. There was a different concept, which is quite often a grandparent, for example, for whatever reason, would become the primary caregiver of a child, perhaps because the parents had divorced, perhaps because there was a birth of a child and it was not clear who the father of the child was. For whatever reasons, there were people in deeply intense relationships with children. The law has a sort of overriding principle that when an issue of children comes to the court, we look to the best interests of children. And over again, we saw in the courts that the old laws simply were not addressing the best interests of children. And Massachusetts, in an early decision, I mean early when I say this is the late 1990s, it's not so early, had said that there was something that we termed, it's no longer used in the courts anymore, a de facto parent, somebody who had really taken over the care of children. Now that became important in same-sex relationships because if you were not married, if it was a relationship with two women, the birth mother obviously had custodial rights, but the birth mother could, and sometimes in divorces, it can be very angry, separations, I shouldn't say divorces, because people couldn't get married, would say, I'm denying you all access to the child. And the court was asked to say, no, here are two people who have been close to rearing this child. Is it in the best interest of the child that the birth mother have the right to deny all access? And those are the kinds of questions to which Mary was referring when she said that GLAD was facing all of these questions that wouldn't normally be questioned. Well, fine, you let the non-birth mother have access to the child. Does she have to pay any child support? Difficult if you don't have a marriage certificate. So in the context of Massachusetts, the history was both the sort of long-term history of what marriage meant was important. Equally important was what the claims were about why the Commonwealth was denying access to marriage for same-sex couples. And I think this other part was a very important part of that. And so the case is argued. And as I say, I've read the briefs and I listened to the argument. And then we have to decide. And at that stage, there's 7 justices on the Supreme Judicial Court, and I don't have a clue as to how they are thinking about this. Not a clue, frankly. The decision, as you know, or you may not know, I can tell the audience now, there were 7 justices on the court, 4 justices were in favor, and 3 justices dissented. They would not have agreed to same-sex marriage. And one of the things that the justices and I did, and I think it's reflected in the work of both, is that the justices who dissented and I and the justices who were with the majority tried very hard to make it clear to whom, to make it clear to the litigants and to you, the public, why we were deciding the way we were. The chief writer of the dissenting opinions was a wonderful justice, Justice Martha Sussman, who's no longer, she passed away. And she and I took a lot of stuff out of our joint opinions. It took a long time. It took a very long time to write these opinions. But one of the things that we wanted to do was to make clear that we weren't just shooting arrows at each other. We were really trying to get people to understand why she, with a deep respect for the Massachusetts Constitution and the dissenters, and me, with a deep respect for the Massachusetts Constitution, didn't agree with each other. We just didn't agree with each other. Could we explain that so that you, non-lawyers, could understand? And so the decisions came out. Did I expect the reaction? No. I really didn't expect the reaction that followed. I knew it was an important decision in Massachusetts, and I knew it was a decision that national media were interested in. Why did I know that? Because we had a wonderful woman who ran the communications for the Supreme Judicial Court, and she kept saying to me, Chief Justice, when is this opinion going to come out? Because she kept getting called. The Supreme Judicial Court has a rule that we will issue all decisions, if we can, within 130 days of oral argument. So you start the count, and I suspect that Mary Buonato was counting, and she probably had it, and then the 131st day, 132nd day, 133rd day, 140th, I don't know how many days, don't tell me how many how many it took to write it, but a lot of that was sort of trying to get it stated. And so the decision goes out, and there was a huge reaction, huge, overwhelming reaction, national reaction and international reaction. And it can be, how shall I put this? The applause and the criticism were very loud, and it was very hard to find one's way around it. Now, the one thing I think that I, at least as a judge, I don't really like hanging out there on my own. So the next thing that happened was the case had been argued in the highest court in New York. Within state courts, there are certain courts that garner perhaps greater respect because of where they're situated. New York is New York, it's a major area, it's like Boston, they have more cases. And so we were waiting for the decision. I was waiting, not we, I was waiting for the decision. New York comes out, 4 votes to 3 against same-sex marriage. Oh dear. Next is New Jersey. 4 votes to 3 against same-sex marriage. Now it's beginning to feel a little lonely. And the anti-forces are delighted. You know, the 2 great courts, the New York and the New Jersey courts, have both come out against same-sex marriage. And then Iowa. Iowa, 5-0. 5-0. Very, I think, was it? In favor. In favor. I'm sorry, did I not say that? In favor. I'm not sure if I'm correct. It was I think it was 5-0. It was unanimous. I mean, so terrific. But let me just complete this little piece of history. In Iowa, judges are elected and stand for re-election. And the following election, 3 of the justices were up for re-election. All 3 lost and left the court. So one of the things I want to say in the halls of the Massachusetts Historical Society is we have a wonderful system of justice in the Commonwealth of Massachusetts. Once we are appointed as judges, we are appointed for life, subject to mandatory retirement at age 70. That is a precious gift that John Adams gave to us. It's the foundation of the federal Constitution, and we should protect it for all we are worth. And Chief Justice Marcia Turnus, who I came to know, was a great Chief Justice, not only for her jurisprudence, because she was a great administrative Chief Justice, and she was removed from office and, of course, couldn't serve. 20 years later, some days I feel that it's 2 years ago, and some days I feel like it's 50 years ago. It has been a remarkable story to watch. I realize that my legacy will always be linked to this decision. I did actually write many hundreds of decisions, more than 200, Catherine. Somebody got that wrong along the way. Some of them even made it into textbooks that are taught in law schools. But I just know that when the obituary gets written, I think it'll start with that. It's always been interesting to me to see what goes on before and after. That doesn't always happen. So often if you're a judge, people come into your court, you make a decision, and then you have no idea of what happens to the people after that. At least in the case of Goodridge, it's been very interesting to see what happened afterwards. And of course, you know, the march towards getting full equality for same-sex couples continued across the United States, huge steps forwards, many steps backwards, until I was very privileged to be in the United States Supreme Court when Mary Buonato stood up and started her argument in Obergefell saying, "May it please the court," and argued the case in the United States Supreme Court. So
thank you so much. In addition to this wonderful group of folks here, we have about 150 people online watching, so we want to give the last few minutes over to some questions. If someone has questions here in the room, we can start with, yeah, you can take my microphone, Carol.
I would like to first thank the panel for all they've done for my life and the lives of other people like myself. You've truly given us dignity, and that's something that is a gift that I cannot ever be ungrateful for. My question is for the Justice. How did you deal with the true venom that came out after this decision? I know that you were in a position of being unelected and you were able to make your decision without having to think about going to the voters, but there was things like the president coming out saying activist judges are undermining the American family, and that we're facing a catastrophic question in our society. How did you take this personally, and how did you keep going through incidences like this?
When one takes the oath of office, you agree to decide every case based on the law. And that's what I tried to do, and I simply had to shut out the noise and the threats and the hostility, which, by the way, came across the political spectrum. There were Democrats who were angry, there were Republicans who were angry, there was a president who was angry, there were people running for office who were angry. Everybody seemed to be very angry. It was a very controversial quest that Attorney Bonauto's clients were on, and it had huge ramifications. And many people agreed with it, and many people disagreed with it. And if you're a judge, you try not to hear that noise and make sure that you can go on and decide the next case. I have great respect for trial judges. They're often right on the line, and they often, and particularly in an area of social media, the accusations that are made about parties, lawyers, and judges in particular are not easy. And I can only say to judges, because I'm asked quite often, you try to block out the noise. Sometimes it can be humorous. I mean, every now and then a friend would phone me and say, I've just seen another banner going past the window. Usually it was from somebody in some high-rise building in Massachusetts, saying there's another banner going past the window that said impeach Chief Justice Marshall. And I didn't take those flippantly. I mean, somebody felt sufficiently deeply, so you try to, treat people with respect. And there have also been many wonderful moments as well. So I'm not sure that answers your question, but the one thing you know as a judge, you try to be as impartial as you possibly can. And quite often, I would read and reread and have my law clerks work with me reading and rereading to make sure that no language had crept in that somehow would make somebody feel. I'll give you an example. One of the cases that I had worked on in an opinion involved the brutal murder of a young woman not married to the defendant. And I looked at all the evidence, and the Supreme Judicial Court decided to uphold the conviction of murder in the first degree. And shortly after the opinion was released, a letter came from the parents of the deceased victim to the clerk of court, which was an appropriate way to go, to say that in my recitation of the facts of what had happened, I had referred to the deceased victim as the girlfriend of the defendant. And in fact, when I looked back at the evidence, it was he who had always called her his girlfriend. She had always rejected him. And so we amended the opinion. It was a factual mistake, but when I was reading it and my law clerks were reading, you try to get it as correct as you can, but sometimes it'll be an error that maybe to me wouldn't have made a difference, because my job was, am I upholding the conviction of murder in the first degree? To the parents of the victim reading this, that's what made the difference. And so that you always have to make sure that all of the parties will feel. When people stop me in the street and say, I argued a case in front of you, I'm always terrified to ask. Did you win or did you lose? They'll usually tell me, what I wanted to know is, if you lost, did you understand why you had lost, and did you feel that you had been treated in a fair manner? That's all I could ask. That's all I could ask.
I'm so sorry, we only have like a minute or so left, and I promised you the last quote. Did you want to take this minute to give us your last quote?
Yes, thank you.
To end this panel.
I do want to say that the history of marriage is a history of change, and that included with people's opinions and attitudes about marriage. So despite those painful losses, we went on to win not only in courts, but also in state legislatures starting in 2009, and actually directly with the people at the ballot in 4 states in 2012, including Maine, where we had rejected a ballot, a marriage law earlier. So I want to just hold that out, that sometimes the most brutal reactions are incredibly painful and difficult and have to be taken seriously, but they're temporary. And so I want to read to you a quote that also is very similar to what's...
You can do it.
Okay.
It
It also resonates with a similar passage in Obergefell, and it's this: civil marriage is at once a deeply personal commitment to another human being and a highly public celebration of the ideals of mutuality, companionship, intimacy, fidelity, and family. Because it fulfills yearnings for security, safe haven, and connection that express our common humanity, civil marriage is an esteemed institution, and the decision whether and whom to marry is among life's momentous acts of self-definition. That's from the Chief.
Thanks, everybody. Thank you so much. Thank you. Thank you so much to everybody here and online. what can I say? Well, we're having a gala, I could tell you that. We're having that on June 6th. Carol makes me say it's going to be Doris Kearns Goodwin. But I hope you can see, at the risk of sounding like Lou Gehrig, I am the luckiest historian. And part of it is, as you can see, I'm at the Massachusetts Historical Society. I also was lucky enough to be part of the audience for the Devane Lectures, which were a set of lectures. They're done at Yale. They're institution-wide and community-wide. And they were, the year I was doing it, was Nancy Cott and her getting ready for her book, Public Vows. And it just seems like it's a wonderful kind of like a full circle. So thank you all for joining us. Come see us at the gala.